SanMiguel v. Grimaldi.
Good afternoon, Your Honor. May it please the Court, my name is Charles Bach from Heidel, Petone, Murphy & Bach. I represent Dr. Merrill Grimaldi, a board-certified obstetrician practicing in Bronx County. In granting leave to this Court...
Do you wish to save any time for rebuttal?
I'm sorry.
Do you wish to save any time for rebuttal?
No, Your Honor. I'll let my reply brief do the talking for me. In granting leave to appeal to this Court, the Appellate Division effectively certified two legal questions. The first is whether or not respondents' claim for lack of informed consent is a species or a form of medical malpractice, thereby invoking this Court's unanimous decision in Shepard-Mobley, precluding recovery for the plaintiff mother's emotional distress in an obstetrical case where the child is born alive. So that's the first question. And the second is whether or not this Court should overturn the unanimous decision that was reached 20 years ago, authored by George Bundy Smith on a court that was well-respected, and a decision that's been cited over and over again.
Could the Appellate Division affirm with Shepard-Mobley applying? Could they properly have affirmed the case?
No, if Shepard-Mobley, we say, applies to claims for medical malpractice, everybody agrees with that. They also apply to claims for informed consent.
The dissent, you would argue, was correct.
100%. Allison Renwick got it right. Absolutely. Shepard-Mobley applies. You cannot, let me step back for a second. The claim for lack of informed consent.
Why aren't they different torts? Why is med mal and informed consent just two different animals?
They're not.
Let's cut to the chase.
They're not. Okay. Informed consent is a statutory cause of action. 2805D spells out exactly what a plaintiff must prove to prove a claim for lack of informed consent. The name of the statute is medical malpractice, limitations on medical malpractice actions in the form of informed consent. It's a limitation on the action. It requires an expert to set forth a standard of care for what a physician about to perform a procedure gives an informed consent to her or his patient. So it is clearly a form of malpractice. This Court recognized that in Carlin.
Because of the title the legislature gave it?
No, because it's a malpractice case. It's a malpractice case. It's based on a procedure that a physician has performed. That plaintiff
but the claim is that the patient really didn't understand. And you didn't properly explain to them the procedure and the risks. That has nothing to do with whether or not your conduct as that physician was one that otherwise, with respect to whatever procedure you engaged in, was done within the confines of professional responsibility action.
Most respectfully, Judge Rivera, there is a standard of care for obstetricians with respect to mothers in labor. Experts set forth that standard of care, both when they talk about departures that result in harm, and the departures could also be in information. So it is the same general ambit of informed consent. This Court recognized it in Carlin.
They seem very different, right?
They're not.
Well, let me tell you the respect in which they strike me as different.
You have the different theories, but go ahead.
Okay. You could have a physician who performs whatever the particular procedure is flawlessly, and that procedure could result in certain adverse effects even when performed flawlessly. And if the risk of those effects are not adequately explained to the patient, you could have, I assume, a claim for lack of informed consent, right?
Well, you could have that claim.
Okay.
That's true.
And so in that respect, they seem distinct to me because the first has to do with the mechanics of how the procedure is performed, physical, right? Okay. And the second is, did I tell you in advance what might happen down the road?
But you cannot segregate informed consent and say you're entitled to different types of damages. That's the key, one of the keys to this case.
What exactly do you mean by different types of damages? Because it could be, I would think that if I sustain some adverse effect, and the procedure was performed flawlessly, but I wasn't advised and I didn't consent, what would the measure of damages be?
So for example, any surgery, you have an adverse effect, you have a scar, right?
Well, let's take a different one. Let's assume an inevitable risk of surgery is the risk of infection, and someone sustains an infection and, is severely harmed and was not informed in advance that that's a risk.
Well, then that first of all, I can't imagine that actually going to court. But second of all.
Okay, but
I'll let
indulge
you-
my hypothetical.
Then that plaintiff would have to prove that no reasonable person in that plaintiff's position would have undergone that procedure. And would have to prove it wasn't an emergency procedure.
And if she did, what would the measure of damages be?
What happened as a consequence of her infection. So if she stayed an extra 2 days in the hospital, the damages would be the cost of the extra 2 days in the hospital. But what I'm saying is, the court below said informed consent is a totally different animal, and we're saying it's not, and that courts have universally recognized that informed consent.
What do you say with respect to the argument that we should accept the invitation to overturn Shepard?
Well, I'm glad you asked me that, Judge Troutman, because your court back in 2017 in Brashaw versus Cohen specifically said, no, Shepard remains good law, and if the plaintiff, in the case that you joined all of your colleagues, it was a per curiam decision that it was unanimous, you specifically said that if there's going to be an expansion of recovery, that's a matter for the legislature. And that's what we're saying here.
The court, are you referring to my being on the Fourth Department?
Yes,
And now I'm on the Court of Appeals.
correct.
So there is a difference between what I could do. I had to follow the Court of Appeals precedent. So what I'd like to ask you is Shepard Mobley, is that a creation of this court, or is it a creation of the legislature?
Well, no, so Shepard Mobley, when the opinion was authored by Judge George Bundy Smith and joined by Judge Kay in her court, that opinion specifically recognized, common law precedent. That opinion, unlike the Tebbit case, I'm sorry, I think we need to go back to Broadnax. So in Broadnax, the same court, with the same judges that I've mentioned, said, you know what, Tebbit was a peculiar result. It would allow recovery when the fetus is damaged in utero. It would allow recovery for the mother's physical injury. If the mother, however, gave birth stillborn because of obstetrical negligence, it barred recovery. So that peculiar result needed to be fixed and rectified. And that's what the Shepard Mobley Court said in Broadnax.
But isn't it something of a peculiar remedy? Because it seems to me, and I understand what they were trying to do, but the measure of damages in the Broadnax case is for the mother's emotional harm, right?
For the stillborn, right.
For the stillborn, in utero. If the child is born alive and dies 5 hours later or a week later, there's a wrongful death claim. The damages that the child gets, or the estate, would be what in that case?
Conscious pain and suffering, and the jury would hear the entire,
But the
all of the
conscious pain and
facts.
suffering is of that infant.
Yes.
Right?
Yeah, and that could be
So-
substantial. And when the plaintiff's lawyer...
I'm sorry.
I'm
It
sorry,
seems
Your
to
Honor.
me that what Broadnax was trying to do was even out two things with two very different measures of damages, right? So in the one case where the child dies in utero and does not have a wrongful death claim
Right.
under our law, you get this recovery for your emotional damages, which to me are very, very different than the child's pain and suffering. And those emotional damages are the same for the mother whose child dies 5 days later.
And the emotional damages of a mother whose child survives to adulthood, she's not entitled to recover for emotional damages.
Right.
And that, because this court recognizes that there is it's an amorphous claim, emotional damages. I understand this is an extraordinarily sympathetic
My point is
case.
I see what Broadnax was trying to do,
Right,
and Judge Kay was trying to do, but it seems that the remedy this court imposed doesn't make much sense in terms of the types of damages that you're being compensated for.
Well, what I would say, what the court said in Broadnax was applies to a very narrow class of plaintiffs who've given birth to stillborns and who have a valid obstetrical claim. That's right? So now we have this case before us where the labor and delivery case, typical labor and delivery case, pending in the Bronx, when the plaintiff's lawyer took the case on, he knew that the recovery was going to be limited to the wrongful death claim on behalf of the child. That could be substantial. So this mother in our case is not without a substantial remedy. That's my
I'm not
point.
arguing that.
Okay.
But or asking about that, I'm curious that a mother who has, let's assume the case, there's malpractice, mother has these types of emotional damages, child dies in utero, can seek compensation. Child dies 5 hours after birth, you wouldn't say that mother's damages goes away, right? They're still there. She legally is precluded from bringing a claim for that injury because the child can recover for a different injury.
Look, yes, she has an avenue of recovery that is substantial, unlike the Broadnax
So what
plaintiff
does that-
who
what
did
does-
not have any recovery.
What does that
Who
mean?
would not have had a recovery. What does that mean? You go
Yes.
to a,
I thought that it was as Judge Garcia just laid it out, which is that the recovery is with the child, not with the mother for the...
the
for any-
mother's the administratrix of the estate. The
but-
mother is the plaintiff
but-
testifying before a Bronx jury. The
Yeah,
mother,
that I
she's
understand.
going to get a big
but-
award. That's my point.
Okay.
But on a different cause of action.
Absolutely, different cause of action, but she's got a remedy, whereas the Tebbutt plaintiffs did not have a remedy. That's what I'm saying. I'm sorry if I didn't make myself clear, and I apologize, Judge Halligan. I didn't mean to cut you off.
Well, but I'm sorry, the other point that you were hearing is that not only is it a different cause of action, yes, the mother still has recovery, but not only is it a different cause of action, it's a completely different type of damages.
Okay.
It's the conscious pain and suffering of the child versus the emotional distress
Right.
of the mother. I think the cases would be exceedingly rare where those two damages are, in any sense of the word, comparable. Either in
And presumably along those lines, the way in which you would prove them up would be very different, right?
I agree
What someone
with-
would testify to as to each would be quite different, even if, I take it your view is, the dollar amounts would be significant in both circumstances, so the differences are not material.
Yeah, well, I go back to stare decisis. The question was, should Shepard-Mobley apply? And the answer is yes. There's no reason for this court to overturn Shepard-Mobley. It was controlling precedent in the court below. It was a well-thought-out and balanced decision.
Well, let's say we
And
disagree.
only the
Excuse me,
legislature
excuse
should
me. Let's say we-
extend this.
let's-
Go ahead,
let's-
Judge
let's try
Rivera, I'm
some-
sorry.
Some concerns about Shepard Mobley. I mean, look, hasn't the court already found that the doctor has a duty to both the pregnant... Excuse me,
absolutely.
I didn't finish the sentence.
Absolutely.
So how can you answer if I haven't finished the sentence?
Well, I mentioned that
To
first
both the
point.
mother...
I'm agreeing
and-
with you.
Okay,
ahead.
to the mother and the child. And so then I'm having great difficulty understanding why Shepard Mobley says that once there's a duty owed, the mother can't recover for damages incurred as a result of the breach of the duty.
Because it's a policy decision about the extent
And we might revisit that.
of recovering. Well,
We might revisit that. We do that all the time on these common law cases.
you do that when there's compelling justification to do that, when there's been a major societal
Maybe some of
change.
what you heard in the questioning suggests that there may be there
Well,
is a compelling justification.
I'm hopeful that this court would say, you know what, if we're going to extend damages in an obstetrical case where our obstetricians in this state are paying the most premium, the highest premiums in the United States of America, the most subject to suit, leaving the practice
Well, you
quite in
can argue
droves.
that to the legislature.
Well, that's what I'm saying. The
We're
legislature
talking
will have to
about-
consider all of that.
Excuse me, I'm talking about the logic if the court has already held that there is a duty of care owed to the pregnant woman and to the fetus.
You have to, it's not just, you have to prove duty of care, which we agree. You have to prove breach of a duty, and the breach of the duty in the course of delivering,
Yeah.
as Judge Halligan recognized, is different from the breach of the duty in the course of informing a patient.
But the
In this
information
case,
is
the
about the delivery, and unfortunately, you have a doctor who says, I do it in the moment.
Well, this was an emergency situation, so maybe informed consent doesn't even apply when my client came into the room. But that,
You can get
but-
to the merits if the cause of action survives.
yeah, so what I'm saying, what I'm saying is that the statute that created informed consent was created to limit, not expand, the liability of physicians. So now I think it's a great irony to say that now we're going to expand it based on that statute. Yes, Your
Could I
Honor.
ask you something? I didn't ever practice in this area. So when you say that a child lives to 8 days would have a substantial recovery, what on average would you expect that to be? And how would that be different from, let's say, a child who has the same problems but lives a whole year?
The testimony from a plaintiff's expert, and I've tried several of these cases.
That's why I'm asking you.
Is any minimal level of awareness entitles the patient or the plaintiff to recover from conscious pain and suffering. It's just any minimal
Right,
level of
For
awareness.
the period of time that that person is
And-
alive.
Right. So the
8
lead case
I
from
mean,
the second
not knowing
department.
anything about it, but I would think that 8 days is a pretty short time compared to a year of pain and suffering.
Okay, well, the second department in the Lee case say 3 days was worth $3 million. So maybe 8 cases. Well, and this is what I'm saying, Judge Martin. What I'm saying is these get to be very, very expensive cases to defend. They have resulted in an overruling a well-reasoned decision that was unanimous from this court 20 years ago.
But let me
We'll-
just
we'll-
stop
we'll
you there for a
be
second.
careful what we
because-
ask for.
Because you're having to defend the case vis-à-vis the infant already. So I'm not sure how much incremental expense there is to defending the case.
No, but I mean judgment cost.
Ah.
Every line that you put on a jury verdict sheet
I understand.
creates a bigger judgment. And there's been real concern in the state of New York with respect to emotional damages. I'm sure you all agree with me there, because it's amorphous. And some jury could award millions and millions for this mom's emotional damages. And what I'm saying, that extends the cost of liability, and that's for the legislature to talk about. We've had the wrongful death statute that's been passed 3 times by the present legislature and vetoed by the governor.
That's much more expansive than this, right?
Much more expansive, but it's the same. To me, it's very analogous. What I'm saying is, since there are no compelling justifications to overrule, frankly, a decision that I've only heard good things about, every court, including the Fourth Department, cited it
Is it
with.
consistent, is that decision consistent with the national trend?
You know, Judge, the national trend is to put caps on verdicts. That's the national trend. So I think
But
we
do
should.
they allow recovery to the mother?
Well, my adversary cited cases which would indicate that the majority of jurisdictions do not allow emotional distress recovery. So the mother is allowed recovery for the actual injury that she suffered. So if there was a C-section and she got septic and had a horrific course, and God forbid, really serious injuries, and the baby also was neurologically impaired, then she would have a separate right of recovery that would be very, very substantial. And what I'm saying is, to this court,
But are you
Please
also
defer
saying
to the legislature.
nationally there is no right of recovery for the mother if the baby survives
No, there are
for 5
states
hours.
there are states that allow recovery, and I'm saying many of those states put caps. So right now,
So that allows an argument to the legislature.
Correct.
this whole thing should be
What's the
deferred to
argument for the
this
legislature?
whole thing should be deferred to the legislature.
Well, not.
But I don't think I'll
not
ever
this-
see-
Excuse me.
I don't
Not-
think-
Excuse me. Not this court's decision to expand or contract the common law.
If this court were to overturn its own precedent, it seems to me, under this court's prior rulings, would have to say, we have compelling reasons to do so. Circumstances over the last 20 years have drastically changed, and none of that exists. And that's what I'm saying. Follow the
But
precedent. It was a good decision.
Made plain the illogic.
Excuse me?
Made plain the illogic of the reasoning in Shepherd v. Mosley, as demonstrated by the facts of the case.
Yeah, and Shepherd v. Mobley was logical and continues to be so.
Well, how can
And
that
it-
be when you've
and-
already conceded to me that the court has already recognized a duty of care to the mother?
I'm sorry, most respectfully, Your Honor, that's not the issue here, duty of care to the mother. That's a given. The issue here is whether or not this court is going to allow a new avenue, a new line on a verdict sheet, new element of damages. That's the issue here. And what I'm saying is, the court below was bound by Shepherd Mobley. It was good precedent 20 years ago, and it continues to be good precedent by a very distinguished court. And I'm asking your honors to please tell the courts below, follow our precedent. Thank you.
May it please the court. James M. Catterson, along with Danielle Stefanucci for Pillsbury, Winthrop, Shaw, Pittman, on behalf of St. Barnabas Hospital. I'm in an unusual position of...
Sorry, Mr. Catterson, do you also want no rebuttal time?
I'm sorry, Judge. If I could reserve 4 minutes for rebuttal.
4.
I will try and be brief because I know the hour is already late. And while I wanted to wade in on the earlier argument, I didn't. I'm in an
Much
unusual
appreciated.
position. Thank you, Judge. I'm in an unusual position of asking this court to uphold its own well-settled precedent. I understand that there are questions about Shepherd Mobley. I do. This court and its relationship with stare decisis has always been exceedingly clear. A long-settled rule should only be re-examined if, one, the policy concerns underlying it are outdated, or two, the rule has proved unworkable.
On the unworkable point.
Yes, Judge.
So to return to an exchange we were having with your co-counsel, it does seem to me that the nature of damages sustained by a mother and an infant is inevitably different. And I'm trying to understand specifically with informed consent, right? My understanding is that a claim on behalf of the child for informed consent is still pending. Is that right?
Yes, Judge.
Okay. So how would you go about proving up damages for informed consent on behalf of a child as opposed to a mother? And I understand the mother may be the administrator of the estate, but setting all that aside, what does a breach of informed consent claim look like for the child as opposed to the mother?
I doubt, Judge, that there would be any difference in proof in terms of, although the court has characterized it as wrongful death, it's not its medical malpractice. I doubt that there's any difference in how an attorney puts that case on.
So obviously the child can't consent, right, or
Judge.
not. So the proof would be, did the mother engage in informed consent?
Yes, Judge.
And so what then would the metric of damages be? Would it be that the, a reasonable person in the mother's shoes wouldn't have consented and therefore the procedure wouldn't have taken place? Is there any difference in how we would assess damages for a claim on behalf of the mother versus the child?
No, Judge, I don't think there would be any real difference. But to be fair about this, that is in my view, mixing the difference of the quantum of proof versus whether or not the claim exists. And the
I do
question-
understand that.
I know you do,
Although,
Judge.
but if we look at Tebbit and Broadnax and Shepard Mobley, right, part of what the court seems to be concerned about, and this is why I'm thinking about the unworkability question, is ensuring that there are not peculiar results that seem unfair because there are certain injuries that, for which recovery is unavailable and that seems ill-advised. And so that's why I'm trying to understand whether an allegation of a lack of informed consent still can give rise to recovery, whether it's on behalf of the mother or the child, which seems to sound in the questions that are at play in Tebbit and Broadnax and Shepard Mobley.
I would suggest, Judge, it can't be that we decide to jettison stare decisis because the claim for the mother is worth more and more susceptible of proof. It can't be. This court has recognized over and over and over again that you have to draw lines. You have to draw lines.
Yeah, but this court has also made exceptions, so why isn't this case an exception to that?
There's always going to be, and that's the problem with line drawing, there's always going to be somebody who's an exception or somebody who has a worse set of facts who wants to be on the other side of the line.
Well,
That
we have-
happens
we
in
have-
every single demarcation in tort law.
So we have drawn a line here, right?
Yes, Judge.
And you'd like us to keep that line. In Shepard Mobley, how long did the child survive? Do you recall?
I don't know the answer to that, Judge.
Was it into adulthood?
I don't
Not sure.
know the answer, Judge.
So let me ask it bluntly. Would it be possible to retain Shepard Mobley and say this is closer to being stillborn, living for 8 days, than living many, many years?
Judge, the answer to that is what I alluded to earlier. In all seriousness, is it 30 seconds? Is it 20 minutes? Is it 1 day? Is it 5 days? Is it 8 days? I don't know the answer to that and how any court draws that line. I do know that this court observed there can be no doubt, and this is from Howard against Letcher, it's quoting Tobin, and I know you're all familiar with the case. There can be no doubt the plaintiffs have suffered and the temptation is great to offer them some form of relief. There's no doubt about that. Ideally, there should be a remedy for every wrong. This is not the function of the law, however. For every injury has ramifying consequences, like the ripplings of the water without end. The problem is for the law is to limit the legal consequences of wrong to a controllable degree. And it's, I know my light's on, Judge, if I could just finish that. That problem has bedeviled this court over and over again. And this court, in all of the zone of danger cases, which, by the way, have never been imported to medical malpractice in New York history, but in all of the zone of danger cases, this court made plain that you can't consider just the harm to the plaintiff. You need to consider the harm to all of the stakeholders in this. And on my rebuttal, I'll get to that. But let me leave on stare decisis with this, and it's, Judge Rivera, it's your dissent in People Against Wortham, which, Judge Wilson, you joined, where you said, quoting Matter of Brooks, another case from this court in 2016, and this was a hard-fought case. I know you remember it because it was a long writing on stare decisis. In the rarest of cases, we may overrule a prior decision if an extraordinary combination of factors undermines the reasoning and practical viability of our prior decision. An extraordinary combination of factors. And what did the First Department say was that extraordinary combination of factors? Common sense justice. Or redress for substantial wrongs. What did the plaintiff say about that? And by the way, the plaintiff never urged in Supreme Court that Shepard Mobley should be overturned, and the plaintiff didn't urge it in the appellate division. The plaintiff said, well, we now have greater value on women.
So do you argue that it's not preserved?
Well, it's not preserved, Judge.
And
It's
Well,
not.
we're
Could
the
they
only
have-
ones who could overturn it.
I agree, Judge. I agree, although the First Department seems to think it could have, because it did.
No, it said even under Shepard Mosley, but the Court of Appeals should consider it. We're granting leave.
That was the alternative holding, Judge. It knew that it couldn't do what it did.
Sure.
It knew it. It did it anyway. The question, and I know I'm imposing on your patience, There are no extraordinary combination of factors here that would lead you to depart from stare decisis. In the 20 years since Shepard-Mobley was issued, it's been cited 225 times. Not one court has said that Shepard-Mobley was wrongly decided. The rule is workable. Nobody likes it. I get that. Nobody likes it because these cases are all horrible. They just are. But it's not just the plaintiff.
225
Cited 225
citations
times.
over 20-some-odd years, not a lot of cases. So I guess it's a small population that would be affected if we chose to overrule Shepard-Mobley.
I don't know if it's a small population, Judge, because the effects will trickle down, and I'll get to that in rebuttal for my client. But thank you very much for your time.
Fair enough.
May it please the Court, I'm Annette Hassapidis Law Offices, with trial counsel Maria Wakesman of Schreier and Wakesman appearing for the plaintiff. The plaintiff asked that this Court hold that Shepard-Mobley is now opposed to logic and experience. And I'd like to, if the Court would indulge me for a minute, address some of the concerns from the Court about the discussion of precedent.
So is your position, I'm sorry, is your position that Shepard-Mobley should be overturned, or that there should be a distinction for informed consent versus regular malpractice, medical malpractice?
To rule in favor of my clients, the Court can find the distinction as found by the First Department. However, in the interest of consistency and logic, it should be overturned altogether.
Okay, now you didn't argue that below, correct?
I'm sorry?
You didn't argue that below.
What we argued below in the Supreme Court for preservation purposes, is that what you're referring to, Judge Singas?
Yeah, I'm trying to figure out if maybe the claim is waived, honestly.
It was at page 2075 of the record, at paragraph 45 of counsel's affirmation, he stated that the failure to obtain plaintiff's informed consent to the use of the extractor and the violation of her physical integrity by its use not once but twice gives rise to her emotional damages. Defendants understood this to be the claim because in a reply affirmation at page 2103, counsel insisted that because plaintiff didn't claim that the use of the vacuum extractor caused her any physical injury and she did not cite an independent physical injury, her claims were precluded. So respectfully, the claim is preserved. Defendants understood it as seeking a deviation from Shepard-Mobley, which would...
Yeah, I mean, fair point, but a deviation and overruling of precedent are two different things. So are you proceeding on both of those now? I'm just trying to see, I'm
Yes.
just trying to frame your argument.
Yes,
Okay.
yes. The limitations of Shepard-Mobley should no longer be followed. The reason that this precedent is, that we're here today is because of the way that this precedent has developed. First of all, cases involving childbirth between a woman and a child have developed in a separate niche, apart from other tort cases. We have negligent infliction of emotional distress cases where there are no limitations on proofs such as proving an independent physical injury, as we have in this case. Plus, this is uniquely an area confined to the common law, so this court addresses disputes as they arise, and that's why we wind up with sometimes illogical results.
So has there been a change in the case law, the jurisprudence, since Shepard-Mobley when it comes to emotional damages?
Well, we've expanded. In the last 20 years, since Broadnax, there has been an expansion in our recognition of emotional distress damages. The Grieving Families Act is a great example. The legislature has thrice said
But it
that
hasn't passed. I'm talking about the case law.
in the case law, Your Honor, well, in Green, this court held that
They are correct, that you've got to have a reason beyond, I didn't like the decision,
No.
for overturning precedent.
Yes, the reason is that the status of women and children have changed in our world in the 20 years since
How is
Shepard-Mobley.
that?
We've passed the Equal Rights Amendment. The legislature passed the Child Victims Act, giving recognition to the status of children. You have to remember, when this line of precedent began...
Isn't that an argument for giving a wrongful death claim to a child that dies in utero? If you're saying the rights of children have changed.
It is the
That would
value...
even things out, right?
No. In this case, and I must take exception to counsel's argument that there would be a substantial award in this case. If this
I
case...
wonder, just to go back to the statutes for a moment.
Yes.
I wonder if that doesn't weigh in favor of a view that the legislature is attentive to these questions, and so a change like the one you're proposing could come from the legislature, which, as you noted, has considered it.
Well, I would point out this is uniquely an area of the common law. It has always been addressed by this court in terms of the common law.
But I think that's why we're trying to understand, or I'm trying to understand, are there shifts in our case law or in the case law of the appellate divisions that would warrant, you're asking us to overturn Shepard Mobley entirely. So what in the development of our common law would warrant taking that step?
Well, I would ask the court to look at the 2007 decision. It was from the Supreme Court, Bronx County, but it was from Judge Renwick before she was a presiding judge and when she sat in Supreme Bronx. And the case is Mendez. In Mendez, the child was born, lived very briefly, and the mother pressed a claim for emotional distress damages. And in that case, Judge Renwick held, this court finds that the considerations in the case are identical to those in Broadnax, and the outcome should be the same. In this case, it's uncontroverted that the baby had no consciousness or awareness. As a result, the estate cannot claim damages, in which case there can be no recovery, since there can be no recovery for conscious pain and suffering without some level of awareness. And so the considerations of Broadnax apply in this case because this child was never
It's
conscious.
still the rule? You would concede in a case that there can be no pain and suffering under those conditions?
Excuse me, Your Honor?
You would concede in a case you brought that there could be no pain and suffering award under those conditions
Not for the
today?
child, yes, and I disagree with counsel in stating that there would be a substantial award. If this case were tried to a jury tomorrow, counsel would argue that the child had an APGAR scores of 0, 3, and 4 at birth, and at 10 minutes, 1, 5, and 10. I would refer the court, to our expert affirmation on page 2084 of the record, where he cites that the baby was denied oxygen in utero. He had a
But
significant...
in any event, harm to the mother, damage to her in the instance that you're asking for, is distinct from the harm to the child.
That's correct. But that is a distinction.
But it doesn't necessarily, are you arguing, mean that she should not have her independent right to recover?
That's correct. That requirement discriminates only against women in childbirth. To press a negligent infliction for emotional distress claim, a party does not have to prove that they suffered an independent injury.
What about the informed consent claim? So it is right that the claim on behalf of the child is still underway. Is that
Yes.
correct? So how is that distinct from the claim on behalf of the mother for informed consent?
Well, the mother, when she gave her consent, not realizing that she was not informed of all the risks and alternatives.
Right.
She agreed to a violation of her physical integrity.
Yes. I don't think I asked the question very precisely. How would a claim on behalf of the child for lack of informed consent be different from what you just described in terms of the mother?
Well, the injuries to the child would be limited. The child lived 8 days. As I was alluding to earlier.
So if the mother were allowed to proceed on the informed consent claim, right?
For her emotional damages.
So
yes.
the distinction would be recovery for emotional damages, not anything tied to the consequence of the procedure and whether or not, reasonable person would have agreed to undergo the procedure if they fully understood the risks?
Yes, my client had sought out and provided informed consent for a cesarean section. She requested a cesarean.
I'm just trying to understand
Yes.
the theory of damages.
Yes, that's the theory of damages.
Okay, so emotional damages for the mother, and for the child, if an informed consent claim proceeds, how do you go about assessing the damage and quantifying the damages?
Well, under the cause of action, we'd have to establish that how the child would have otherwise survived, and the defendants would likely argue that that was speculative in any event, because the goal is to put the person back in the position they would have been in had the proper advice been given. She would have had a C-section and a
So in
healthy-
that respect, similar to the way, again, I have not practiced in this area, so I'm just trying to understand the
Yes.
basic parameters.
Yes.
It would be similar to the measure of damages for a more traditional medical malpractice claim in that regard, I take it?
Yes, but again, to just bring it back, it's a legal fiction to assert that there is redress here against the tortfeasors if the purpose of the tort law is to ensure that people comply with their duties of care to others. It is not achieved by going to trial.
That's true 20 years ago. The problem I have that I'm struggling with Broadnax is the goal of the court and Chief Judge Kaye was to do some justice there, right? There was a claim. If the child died in utero, there was no claim. The child lived 2 days, there was a claim. And the court was trying to even that out a bit. The way they did that, to me, was to give a claim for something that isn't exactly the same as I think you're saying, with what the claim is that the child has, it survives. But the court 20 years ago knew that, and they made that decision, and I think there's a footnote saying, yeah, we know we still haven't given a wrongful death claim. In other states, they do that too, to give a full recovery. We're not doing that.
Right.
They struck a balance. Now, you can say it's a rough balance, right? You can say it's not an equal balance, but that's where the court struck the balance. The arguments that seem to resonate are that there's something wrong with that
Yes.
formula, let's
Yes.
say. But it was wrong then. So, and the court knew it wasn't an equal type of measure, but they were doing the best they could to make up for the fact that these other problems existed in the law. Why should we overturn that case today because we do that calculation differently?
Because wisdom and experience have shown us that there are many child who take one heartbeat, and that precludes recovery. It has shown us that there is no
But
logical
they
connection.
didn't know that 20
Yes,
years ago?
but it was 1 year after Broadnax, and change comes slowly. And it is not surprising that 1 year after sustaining claims for emotional distress as a result of a stillborn child, the court was reluctant
That's
to
a
move
very
the-
hard line to draw, and I agree, this court draws lines. We've talked about that. But there's a clear line, and then what's the other line? I think the Chief Judge was asking this earlier. You know, should we say a week? Should we say 2 weeks? Should we say, you know, where would we draw that type of line? And again, we are sometimes in the business of drawing lines, but there has to be some basis for it. So
Well,
how could we do that?
I didn't mean to interrupt you.
No.
Your Honor, we allow juries to make these decisions every way. Because of the way this case law has developed and because of the fact that we've grappled with in utero injuries, we've drawn lines in this area. But every day, emotional distress, pain and suffering claims go to a jury where defendants argue that 30
Okay,
years...
so let's get to that, because now you're getting to the question I asked before, I still didn't get my answer. What has changed? It's part of what you're already hearing several members of the court ask, between when Shepard-Mobley was decided and today, beyond some members of the court may think it was wrongly decided. Is there something else?
In terms of precedent, we have seen Judge Renwick and Mendez holding that Broadnax, the considerations of Broadnax apply here. You had the
Okay,
Second Department...
can I ask maybe another way? So you're asking for a subset on informed consent for mothers giving birth, is that right? Or are you making a more broad ask of us in informed consent cases?
It is really both. The line drawing of the requirements of Shepard-Mobley that there be an independent physical injury.
Well, it can't be both. I mean, it has to be women who are giving
Then
birth, and then I'm going to say to you, times have changed, and there are surrogates. So what would happen if a surrogate is giving birth? Who has a right of action there?
The surrogate, it's her physical
Well, what
integrity.
about the mother who's going to, whose baby that is, whose egg was inseminated?
I apologize. Because the duty of care in providing informed consent runs from the doctor to the
But
patient.
for emotional distress purposes, why wouldn't it be the person whose egg it is?
Because then that would fall in the nature of a negligent infliction of emotional distress claim, Your Honor. There is no, but again, they would have to, that mother who owns the egg would have to argue that the duty of care ran to her from the doctor as well with respect to the egg.
So
And I
again, my
would submit
question
that
is,
that tenuous.
are you asking for a broader informed consent exception to the ban on emotional damages, or are you strictly asking us to look at women who are giving birth?
We are asking that you look at women who are giving birth at a time when mother and child are one. You could not be, I mean, if you were to analogize this to a zone of danger,
But I
could not
thought
be
you were
closer.
asking us to overrule Shepard-Mobley entirely, which I would assume would apply both to informed consent claims and more traditional medical malpractice claims. Did I misunderstand that?
Your Honor, as a threshold matter, to rule on my client's case, you could rule solely on lack of informed consent. However, it is our position that logic and reasoning that support our position also apply to overrule Shepard Mobley altogether.
So if we were gonna take the first path and distinguish informed consent from traditional medical malpractice,
Yes.
and not overrule Shepard Mobley, but say it doesn't apply to informed consent, what would the basis be for treating them differently?
The mother's role in the process. As you pointed out earlier, medical malpractice arises from a doctor's receipt of informed
So
consent.
the notion
from-
would be that the act of consent inflicts uniquely
Yes.
serious emotional damages?
Yes, in my client's case, she felt enormous guilt from not having stopped Dr. Grimaldi from using the vacuum extractor, from not pleading more for a cesarean section.
Counsel, I'd like you to answer before you go, because you were asked and I didn't hear it. If we're going to redraw the line that Shepard Mobley drew, where are we going to draw it?
I'm sorry, Your Honor. we-
If birth isn't the cutoff,
Oh, no.
or delivery isn't the cutoff, where is the line now for these claims?
No, we ask that you draw the line at birth, that the emotional distress claims suffered as a result of torts committed during childbirth be sustained. I did want to point out.
No, but if the mother's recovery is now allowed to a child who's born alive,
Yes.
how far after the birth does that claim last?
That is for a jury to decide based on the evidence
For
before
a
it.
jury to decide? So if the child lives for 5 years, the mother has a claim for emotional damages caused by the doctor's lack of informed consent or malpractice 5 years later?
Your Honor, we decide these issues we allow juries to decide these issues every day. There are guardrails.
We decided
being
this
verdicts.
question as a matter of law previously, just 20 years ago in Shepard Mobley. Now you're saying it's not a question of law, it's a question of fact?
No, it is, the claim can be recognized. The amount of an award would be left
I'm not
to a
talking
jury.
about, the amount of the award could be whatever the jury says is right. I'm saying, when does the mother's viable claim for emotional damages where she has not sustained an injury and the child has been born alive, how long does that claim exist for before we say, as a matter of law, it's too far removed from any compensable injury to the mother?
Well, Your Honor,
Is it a week? Is it a month? Is it a year? How long?
we have not posited that because, as in negligent infliction of emotional distress cases, we allow juries to decide this. We have
But counsel,
judges-
we have to
Yeah.
draw a line. We've all agreed that we are the line drawers. The line was previously drawn, at the point of birth.
Well,
Now you're asking us to redraw it. Please, give us some guidance.
Okay, Your Honor, I would answer it this way. According to CDC guidelines, which we cited in our response to the amicus briefs, 21,000 children per year die within the first year of birth nationwide. So that, when you consider the 50 states, is a relatively small number. The New York State Academy of Trial Lawyers has asked that the court put a cap on this for 1 year. But I submit to you that, again, you're discriminating against women in childbirth by imposing a limitation when we don't do it in other cases where purely emotional
I understand this
damage.
is not the rule you would like, but could this case be decided by saying this child was effectively born dead because the child was immediately put on life support, had the APGAR scores, et cetera, that you reported, and as soon as the child was taken off life support 8 days later, the child was declared dead? So effectively, this child was born dead. Is that
Yes.
a possible outcome here?
That was actually what occurred in the case of Waring decided by the Second Department, where the parties engaged in the unfortunately abhorrent task of presenting expert opinion testimony as to whether or not the child should be considered dead for all intents and purposes. And this court, and the Second Department was constrained by this court's earlier decision and held that the mother was not entitled to recover emotional distress damages. So this court could rule that based on the fact that the child was that there was no evidence that the child ever gained any consciousness, and
Well, a little different, that any child who is immediately put on life support and then is declared dead as soon as life support is taken off is effectively born dead.
Yes.
And that doesn't require an overruling of Shepard-Mobley. Perhaps.
What impact, if any, would that have on the claim for the child?
The child's claim is, again, is a legal fiction, so that would be,
I'm sorry, that didn't help me.
I'm sorry?
I didn't understand that answer, I'm sorry.
Perhaps I
Does
misunderstood
does the
question.
claim change or not with respect to the child? The child's claim?
If the child is considered effectively dead?
Yes.
No, because the claim has really no value. The child was never conscious. It's akin to the Mendez case. But it's more important, the mother was the true victim here. The mother suffered extreme emotional
So
distress.
then you're basically swapping out a wrongful death claim for a different claim.
But it's not wrongful death. I mean, well,
I mean, you're swapping out
yes.
the child's claim for a mother's claim, right? We're doing what we did in Broadnax. We're just swapping claims out, right?
Well,
That's what I'm asking. Is there any claim on behalf of the child if you go down the road of the suggestion that the chief judge has made? That was my question. I'm sorry if I was not clear.
no, I apologize, Your Honor. I'm not reading it.
If the child is deemed born dead, the child can't have a claim,
Yes,
right?
I mean, and that has been our position, that
Whether
the
it's fiction or
contention that
not.
there would be a substantial award is
That's
unsupported
about
by
the
the record.
damages, nothing to
Yes,
do with whether or not
yes.
there's a
So there
claim.
would, there would effectively be no cause of action, and therefore her
It's
emotional...
not a
dis-
wrongful death claim.
No,
Thank you.
thank you.
I'll try to shrink the 4 minutes as small as possible, Judge. I promise. Lack of informed consent. Just to put this once and for all, hopefully off the table, my adversary started talking about, until a question popped up, about violation of physical integrity. That, of course, is the basis for a lack of informed consent claim not being medical malpractice. This state has rejected that since 1974. No case since 1974 has held that lack of informed consent is not medical malpractice. You asked, what has happened about our understanding, an expansion of our understanding of emotional harm? You heard nothing whatsoever about how the common law has evolved on emotional harm in the last 20 years, and I would submit it's because it hasn't. The Grieving Families Act. I understand, Judge Wilson, that it is more expansive than this case presents. It is the quintessential legislative function that is going on now, that if this court steps in the middle, would essentially override the governor's veto. You would be taking all the chess pieces off the board. I say that because the governor specifically vetoed every iteration of the Grieving Families Act up until the latest one. She hasn't gotten to that yet. I expect, because it's the same as the last version, she will veto it again.
So are you saying that the nature of a claim involving a mother and a child are the same as that which they're debating in the legislature on the
Certainly.
Grieving Families Act?
Certainly, Judge Troutman, if the Grieving Families Act passes, it would take this question off the table because it would allow the claim.
But this is a
currently, the argument is that we overrule our own common law. It's not statutory.
You're absolutely, if you act now, you're overruling your own common law in violation of every principle of stare decisis this court has ever uttered in the last 80 years. More importantly, I wasn't being facetious about overruling the governor's veto. In the governor's veto message, she specifically articulated that this is particularly challenging for struggling hospitals in underserved communities. My client is that hospital.
This is a small subset of what the Grieving Families Act covers.
I agree,
Is that
Judge.
fair? Yeah.
It is. But when the governor vetoed it specifically, at least in part, on the effect it would have with all of these hospitals in the state. I know you've read the amicus briefs, and I won't repeat the stats, which are, in my view, utterly astounding about the number of obstetricians who are either now or have been defendants in obstetrical malpractice cases. or that New York has the single highest malpractice premiums on the planet, that California, yes, California took a
And
different...
how would the impact, if the court were to rule in the way that's being asked, could not the legislature impose caps with respect to recovery to deal with what you are concerned about?
Judge, if I was altruistic and less cynical than I am, I would agree with that premise, because that's exactly what California did. California allowed emotional harm in any manner of case, but at the same time, when they imposed the limit, it was $250,000, it's gone up, on non-economic harm. New York has never done that. And do I think that there's the proverbial, I'll use an old Latin expression, snowflake's chance in hell, that will ever happen? No. The only constitutional, unlike the last case, the only constitutional question in this case is actually an important one, because it does go to separation of powers. And the question is, why has the legislature not invoked Article 4, Section 7 of the Constitution to override the governor's veto? They've had a veto-proof majority for 15 years.
But then you're arguing that the politics across the street trumps our common law, our obligation to develop the common law.
No, Judge, I'm not arguing that at all. What I'm saying is there has been an evolution of the common law from 1921 to 2005. That's the evolution of the common law. Right now, they're debating in the legislature that which the legislature is empowered to do. What the
But
common
wait a minute,
law...
what happened to the other 2 decades?
Again,
Isn't
that's how I
that for this
started out,
court to
Judge.
figure out?
That's how I started out, Judge. I don't see any articulation by anybody about how there's been any change in the common law. Thank you very much for your time. I know it's very late. I
you.
appreciate it.